I'm Tom Bayless. I'm here with Gil Sparks. Thank you for being here, Gil. We're going to talk about Weinberger versus UOP. And let's start with the background. The Signal companies were the buyer, and UOP was the seller. Signal already owned 50.5% of the company. The merger agreement was signed March 22nd, 1978. And the proposal was to cash out the minority at $21 a share. Were you involved in the structuring of the transaction or anything pre-litigation?
I don't think so. It's possible, but I don't have any recollection of having been involved prior to the time the litigation began.
I want to touch on a feature of the merger agreement that turns out to be important later in the case. That is the stockholder approval conditions. Right. The merger agreement required an approval by a majority of the minority present and voting at the stockholder meeting, and also 2/3 of the outstanding stock. Do you know the origins of those provisions?
No, I really don't. My guess is, this is a guess, is that Latham and Watkins, who are general counsel, in effect, or outside counsel for Signal, no doubt thought that that was a good protective measure and a way to be fair to the minority of UOP. Whether they consulted with anyone in my office prior to doing that, I doubt, because we ended up representing UOP, not the acquiring company.
Was there any pre-closing litigation?
Not that I recall. And that's interesting because the agreement with respect to the merger agreement, preceded by about 2.5 months the vote on the merger agreement. So there clearly could have been pre-closing litigation, but there wasn't. And I think that may have also colored people's thinking about the case as it began and as time went on.
After the litigation began, did anyone make an argument that the plaintiff should be kicked out of court because he waited too long to bring suit?
Not in the way that you would make that argument today. The law just hadn't developed far enough to in effect, penalize you for not suing before the deal. I don't recall anyone making that argument. I do believe that on at least one occasion, maybe two, Vice Chancellor, later Chancellor Brown, made some mention of the fact that, by the way, nobody challenged this beforehand, and it may well be that it colored his thinking about the suit in sort of a global way.
The stockholders vote to approve the deal, and it closes on May 26, 1978.
Right.
The litigation begins in July of '78. Tell us about the players in the litigation.
So let's start with the plaintiff himself, William Weinberger. William Weinberger had been the plaintiff. I know this because I Googled it up. I knew he'd been in a lot of cases, but I Googled it the other day to see if when it was he passed away, which by now he clearly has, since he was in at least his mid-80s when this suit began in 1978. And he by that time had already been involved in at least 90 federal securities law cases as a plaintiff. He was in a number of Delaware cases, including at least one or two that I know Vice Chancellor Brown commented that he had decided. In fact, I think at one point the Vice Chancellor was remarked that it didn't appear that Weinberger remembered the case that Vice Chancellor Brown had decided that he had been the plaintiff in, which nonetheless, as we will get to, William Weinberger got qualified as a class representative as we went forward.
You mentioned some of these facts, but I do want to touch on them because in a later opinion in the case, the court mentions that at the time he was 81 years old. He had, according to the court, virtually no accurate knowledge of the status of the suit that he had filed. The court went on to say that he was, at the time of his deposition, unaware of the findings and opinion of any financial analyst who had been retained by his counsel to evaluate his contentions as to the value of the stock. He had not met his Delaware counsel until 2 days before his deposition, and 5 months after his suit was filed. And at the time of his deposition, he had no written understanding with his counsel concerning his responsibility for the payment of costs in the event his suit was unsuccessful. And at his deposition, he had virtually no recall whatsoever as to the outcome of several other class and derivative actions in which he had participated as a party plaintiff. When you found out all this stuff, what was your reaction?
That it probably wasn't going to make any difference, but in terms of his qualification. I mean, at that time, it's hard to describe, but I think the courts had sort of taken the view that these class plaintiffs who were sort of wheeled into battle. One of the cases, I don't know if it was whether it was with respect to Mr. Weinberger or somebody else, but one of our judges characterized either Harry Lewis, who was one of the other guys who did this, or William Weinberger as somebody being wheeled into battle by the plaintiff. And the trouble was, if you got one of them disqualified, there'd probably be another one that popped up. And at that particular point in time, our courts just on this particular area weren't very rigorous in terms of disqualifying these people. So I can't remember if we challenged it in this case or not. I think we sort of did in the context of class certification generally, but at least I didn't have much hope that we were going to succeed. It just wasn't happening back then. At the same time, a lot of us wondered, what motivated people like Mr. Weinberger to do this. And very frankly, we were never able to punch through in discovery of the Weinbergers or the Harry Lewises exactly what the quid pro quo was. But obviously, Mr. Weinberger, maybe it's just psychic satisfaction or an 81-year-old wanting to stay in the game. But that was sort of the state of play. Just to jump forward a little bit, the reason I Googled him up was you asked me, and as we thought about this interview earlier, why another name popped up as a co-plaintiff late in the case. And I Googled Mr. Weinberger to see if he had passed away. My guess is the other plaintiff popped into the case because Mr. Prickett was concerned that Mr. Weinberger, by the time this case ended, if he was 81 when it started, he was 88 when it ended, and there was some risk that he might not have a plaintiff anymore, which would have been a sad way to have the case end, at least as far as Mr. Prickett was concerned. But when those types of things happened at this period of time, our courts were very liberal in allowing class counsel to, in effect, invite other people to come in and substitute and keep the case alive, at least if the case had any merit.
Let's talk about the lineup on the defense side. UOP was represented by Sam Arsht and you from Morris Nichols.
Well, I don't remember Sam playing any role whatsoever in the litigation. He may have gotten the call from someone, but Sam was not a litigator, and by this time, he retired in 1980. So by this time, Sam was certainly not taking on new matters of this nature, and he never went to court. I don't think I ever consulted with Sam about the ongoing nature of the litigation. So basically, in our shop, it was me representing UOP, and I looked through the papers. I don't see that I even had an associate working for me. In fact, when the case started, I was an associate. I became a partner in 1979. So when this case began, I was a sixth year associate. And I really didn't have anybody to report to. There was no general counsel of UOP. So I was, nominally, I guess I would take my direction from Mr. Crawford. But after the merger had occurred, UOP was wholly owned by Signal. And the lawyers at Signal, their general counsel was a guy named Brewster Arms. And then they had a senior guy from Latham and Watkins, Alan Halkett, who was really the lead counsel in the case. Now, whenever there had to be a UOP witness, like Crawford or a financial person from UOP, I took those witnesses. Halkett took all the rest of the witnesses. Bob Payson at Potter Anderson was the other lawyer in the case, but since Halkett and Bob represented the same people, and Halkett was sort of doing everything on his side. I don't remember Bob taking a witness. I think the most he ever did was introduce Alan and then move on. I didn't mean that Bob wasn't doing the same thing I was doing, and that is reviewing and editing briefs. But I don't remember him taking an active role in either in the discovery or, for that matter, in any of the arguments before the court.
Let's talk about the signal companies for a moment. Were they a repeat player in the Court of Chancery?
Well, they had been in the Court of Chancery in a very high-profile case called Gimbel versus Signal, which dealt with, if I recall, it was a sale of assets case.
So this wasn't their first time in front of the court.
Well, no, but that had been a while before. I mean, I think that was '74 or something like that. So it wasn't the same team, wasn't the same players. Certainly wasn't the same issue.
Let's talk for a moment about the judge. At the time, Vice Chancellor Grover Brown. At the time the case was assigned to him, did you believe you had gotten a good draw?
Well, I think all of us respected Grover Brown. He was a down-to-earth, common sense, good judge, in my opinion. I certainly was as comfortable with him as I would have been with any of the other vice chancellors or chancellors, perhaps more so.
Did you have a view at the beginning of the case about how it would come out?
No, I learned very early in my practice not to form views as to how cases were going to come out. I just tried them, and there came a time in every case when you think you know how it's going to come out. Even then, sometimes you're wrong. And when the case was filed, not really.
Well, when was the moment in this case when you felt like you understood how it was going to come out?
In the very last argument before the Supreme Court, when Drew Moore started pounding on the Arledge Chatia report, and not before that.
Let's talk for a moment about the initial complaint. Filed in July '78, it's 7 pages long. Any sense of whether, at the time, of whether it was going to be a groundbreaking case
No.
that would have a major impact
No,
on Delaware
the
law?
original complaint had two causes of action, if you will. One of them was that this was a cash-out merger, and under a line of cases involving a case called Singer versus Magnavox, the Najar case and the Tanzer case, the court had introduced into our law some concept that a cash-out merger had to have a business purpose. And that was his count one. No business purpose. This was just cashing out the minority. And the second claim was that the price was inadequate. And under Sterling versus Mayflower and some of the other cases, the burden was on the defense in at least in normal circumstances, in a cash-out controlled merger to demonstrate the entire fairness of the consideration paid. So all you sort of had to do was say, controlled merger, 50% plus stockholders, cashing out the minority, and I think it's unfair, and say a couple of words about why you think it's unfair, and that would generally get you past a motion to dismiss.
There was also a claim against Lehman Brothers.
Right.
Was it usual for a financial advisor to get dragged into stockholder litigation?
No, but we're early enough in this. We're early enough in the whole area of litigation in this area that there's nothing that's necessarily normal or abnormal. But I can't recall seeing an investment banker hauled into court for a fairness opinion prior to this. That doesn't mean it hadn't happened, but it certainly wasn't common. But there wasn't a very large sample either.
Rolling forward to the Court of Chancery's first opinion in the case, which dismissed the derivative claims for lack of standing and then addressed a discovery issue. I want to focus on the discovery issue. What happened?
All right, so there was a relatively late in the document discovery, a document popped up that I can remember to this day the designation of it. It was PXLB 40, Plaintiffs Lehman Brothers 40. And this was a document prepared in 1976 by Lehman Brothers that was addressed to Forrest Shumway, who was the CEO of Signal. And it pined that the that the value of UOP was somewhere between $17 and $21. And or maybe it was that it would be advantageous for UOP to buy, or for Signal to buy UOP, or the minority shareholders, minority shares of UOP for that amount. Now that's 2 or 3 years before the merger, but there had been an intervening. And I don't remember the details of why it was a catastrophe, but it turned out it was. They had some major loss on I think Come By Chance was the name of the lawsuit, which they ended up paying 10 years later tons of money to settle, and it had already had write-offs. So the idea was, well, it's still worth in this range, notwithstanding this calamity. The deposition, I was defending Crawford, the CEO of UOP. And Bill Prickett pulled out this document. Now, I can't remember whether we had prepared Crawford on this document or not. He had never seen it, and I think we may have decided that having never seen it, it was not a very good idea to prepare him on it. And so wait a minute, let me finish the story here. So Bill Prickett puts this document in front of Crawford, forces him to read it at the deposition, and then asks the question, if you had known about this document back at the time that you hired Lehman Brothers, would you have hired Lehman Brothers? That was his question. And Alan Halkett, he didn't jump up and down, but he immediately objected, and then literally kicked me under the table and said, direct the witness not to answer. And it was an objection. I mean, to this day, I'm not sure it wasn't an objectionable question. I mean, it had no foundation. It was pure speculation. And the witness didn't know anything about the document or what its circumstances were. And so then when we had the motion to dismiss, the first one, the motion to dismiss was, why these were derivative claims, to this day, I have no idea. I mean, Bill Prickett wasn't suing, or Mr. Weinberger, if you characterize him as a real person. They weren't suing on behalf of UOP, so money would go back to UOP. They were suing on behalf of the minority stockholders whose stock had been taken away to get them more money. And so it just didn't have it. And on top of that, they weren't stockholders anymore. So it didn't fit in terms of being an appropriate derivative suit in its form, and they also had no standing because they weren't stockholders anymore. And I think Bill was arguing, well, if I succeed in getting rescission, they'll be stockholders again, and therefore maybe there should be a derivative suit. He lost that, and then I had to get up and argue the PXLB 40 thing, and I lost that. Grover Brown decided, well, go ahead, he can ask those questions. Well, of course, by that time, a couple of things had happened. Number one, by that time we knew that PXLB 40 had never been seen by anybody outside of Lehman Brothers. In other words, it was addressed to Shumway, but it had never been sent to him. It never was sent to anybody at UOP. It was sort of one of these things that investment bankers just sort of do internally, and then somebody said, we're not going to send it anywhere. So it had assumed a much lesser importance. And then I am sure, with 2 years to prepare Shumway to answer the question, by the time he did have to answer the question, he had a pretty good answer, which was probably something like, I don't know, because I don't know anything about this, and I never saw it before. I don't know I honestly don't remember what the answer was. But the bottom line was PXLB 40 was sort of a big deal in the first 2 years of the litigation, and by the third year of the litigation, nobody cared about it anymore.
I do want to focus on the document for a moment, because it does seem as if it's the type of red-hot document that any plaintiff's lawyer would want to get. It's the financial advisor to the seller, and they have a memo to the buyer saying, you should buy this company for $21 or something to that effect. And then they represent the seller who agrees to sell at $21, and lo and behold, the same financial advisor advises that $21 is fair. Meanwhile, there have been intervening events that you would think would have allowed the company to recover and exceed $21 a share.
Well, that wasn't completely clear, but yeah, you're right. But it was pretty remote. It was 2 or 3 years before, and once it had never been sent to anybody, so they never assumed a client relationship with Signal. I just think Bill let it drop. I mean, it just wasn't a big part of the case from that point on.
He couldn't prove that document had ever made it out of Lehman Brothers to Signal.
He was able to prove, as I recall, that Glanville, who ultimately signed the opinion, and who was a director of UOP, was made aware, although I don't know if he had known of it before, but he was made aware in the 3 or 4 days that Lehman had to formulate its opinion. He was made aware of its existence. But since the price was 21 and the range was 17 to 21, it just wasn't enough anymore for Bill to hang his hat on, and he had moved on to other things.
Let's roll forward to the class certification decision, April 5th, 1979. You mentioned this before, but the court determined that Mr. Weinberger was an appropriate plaintiff. Would testimony of the type of testimony that you got from Mr. Weinberger at his deposition, would that be sufficient today to justify a class or sustain an application for appointment as a class plaintiff?
I don't know. I'm not sure how many class plaintiffs there are of the ilk of Harry Lewis and William Weinberger, and there were a couple others whose name I can't remember. We were just chatting about this not earlier today. We have pension funds now who are institutional plaintiffs in some of these cases. It might be more of a problem today, but I'm not close enough to it now to really have a great feel for that.
The court also made a ruling on the size of the class and cut it down from the proposed class of 5.7 million shares to 147,000.
Correct.
Which must have been a big blow to the plaintiffs at the time, because they immediately sought an interlocutory appeal, and they argued in their appeal papers that the practical effect of that ruling was to deny class certification altogether. And then the appeal gets refused. At that point, did you think you had won the case?
I don't have any recollection of what I thought when that happened. I mean, obviously, he was going to have to do something. Either the case was over, as a practical matter, or Bill was going to have to do something to change that result, because it wasn't economically feasible to try a case with 147,000 shares. And of course, the reason that it got knocked down was there was no fraud or misrepresentation in the original complaint. And so the only people who really had standing as a class matter were people who had voted against the merger or had not turned in their shares. And that's why it was such a de minimis number, because everybody did turn in their shares, because there was a 50% premium to market for these, for I guess 44% premium. So it was hard to find at that point who was aggrieved and why. And of course, what happened is he amended his complaint to make it a complaint basically sounding in fraud and misrepresentation.
I do want to touch on that, because his original complaint actually gets dismissed.
Yes. But there's some language at the end of that opinion that sort of suggests that the chancellor or the vice chancellor might be willing to entertain a motion to amend. And something to the effect that as the complaint presently stands, it's dismissed, which it takes somebody pretty obtuse, and Bill wasn't obtuse, to figure out, well, the way out of this box is now to shift my theory and look around and figure out what it is I can complain about that constituted a misrepresentation that would vitiate the vote and open up the class to everybody.
So at this point, he has gotten discovery. His complaint gets dismissed,
Right.
but he's able to amend it with the benefit of his
Correct,
discovery.
exactly.
Could that happen today?
Probably not, because we have Rule 15, I think it's, what is it, 15 triple I or some
AAA, right?
yeah. And that says that he would have had to have done it after the opening brief on the motion to dismiss, and if you didn't do it, then you couldn't wait around till you got an opinion. You would have to amend at that point. Now there is a little bit of weasel language in that rule that says, for sort of like for super good cause shown, you might still be able to amend. But I think most practitioners, if they're going to amend, look at the arguments that the defense has made, and amend then, so as not to run afoul of that rule. But that rule was well in the future, beyond this point.
Let's roll forward to the trial, and I want to ask about the experts,
Yeah.
and specifically the defendant's expert who presented evaluation based on the Delaware block method.
Right.
What is the Delaware block method?
So back when I started practice, and as it will come clear as we move forward here, for the first 10 or 12 years of my practice, when you did an appraisal case, you had three factors that you considered. You considered the earnings value, which generally meant that you looked at 5 years of historical earnings and averaged them out, and applied some multiplier to those. You look at asset value, which was what it sounds like, the fair value of the company's assets. And you looked at earnings. You looked at market value. And then you weighted them. And you weighted them based on the nature of what the business was. So the example I used to use was if you had a bunch of land held for development, which was presently a cornfield, that you'd give a higher weight to asset value in that circumstance than you would to a factory that was producing something, because you're already getting value out of the earnings side of the equation from the producing factory. And so, depending on what you were talking about, you would weight these. And market value, the market value before the deal was announced, not taking any consideration of synergies from the deal, was the third factor. And if it was a public company with a widely traded market, you would put a higher percentage on that market value than you would if it were a private company. In fact, in some private companies, there was no market value or no discernible or very lightly discernible market value with a few scattered trades. So that would get a low percentage in that case. So depending on the nature of the company, you then total that up, and that would be your value. You'd apply the weighting to each of them, and then you come up with a number, and then that would be the value. Different from the way people think now, largely because it assumed that the past is a predictor of the future. So you were looking backward, at least in terms of the earnings value and the multiple that you put on it.
The plaintiff's expert conducted a premiums paid analysis and then rolled out a discounted cash flow analysis.
Right.
At the time, did you believe that the discounted cash flow analysis was going to get traction before Vice Chancellor Brown?
Not really. I mean, not only did the Vice Chancellor sort of dump on Bodenstein's discounted cash flow analysis, but other judges in other cases had commented on the speculative nature of discounted cash flow analyses, which varied tremendously based on the discount rate you applied, the terminal value you selected, et cetera. So while the technique was becoming more widely used in the investment community, it really hadn't gotten any traction yet in the Delaware courts. And of course, that's why our witness used the methodology he used, and I suspect Bill didn't like the way that methodology worked for him, perhaps because in the middle of this 5-year historical period, this come-by-chance disaster had occurred, which would have had a major deflating effect on what he was doing. And so he turned to this other method. And there were other things. I mean, as you get into the opinion, and we'll jump ahead to that, I'm sure, but the vice chancellor really didn't like some of the details of the Bodenstein opinion. And the one thing I remember that was, I don't know if it got mentioned in the opinion or not. I know it got mentioned in one of our briefs, but we were taking Bodenstein's deposition in New York. I mean, it's weird things that you remember on cases that you tried almost 40 years ago. And we were taking this deposition, and he came up with a number, and the number was $30 million in our favor. I mean, it was, and he came back from a break, and he said there was a ray of light shining through the shade on my calculator, and I misread the number, and it's really $30 million more in terms of value than the number I had given you at the deposition, which was, I have a recollection the shades were pretty much closed, and it happened after a break, and there must have been a lot of scrambling about what do we do about this number, because I'm sure Bill recognized immediately that this wasn't going to work, and that found its way somewhere into the record. But Brown was skeptical throughout the trial and throughout the damage phase in terms, not so much of, well, both in terms of the methodology, but also in terms of Purcell's application of it. Not Purcell, I'm sorry, Bodenstein's application of it. Yep.
Let's roll forward to the post-trial opinion. It comes out on February 8th, 1981. It's 79 pages. And there's only a tiny discussion in the statement of facts about the Arledge and Chaitia report.
I think there's a line about it at page 67 of the opinion. I mean, it wasn't part of the things that Bill had selected as his disclosure points. He had a point where he claimed that proxy statements said, or not the proxy statements, but a couple of press releases said there was a negotiation, and he didn't think that going from picking 21 versus 20 was a negotiation. And he got some ammunition on that because in the SEC proxy statement review process, early drafts had said it was a negotiation, but the final proxy said it was a discussion. And so that was one of his points. And then another point was sort of one of those argumentative points where, we didn't disclose that Lehman Brothers' opinion wasn't really an opinion because they did it really quickly, and I don't know, that they had a blank in the opinion letter after they flew out, which I thought was actually a good thing because it meant that you didn't actually know before you went to the board meeting what the price was going to be. And so maybe it would have been 23, or maybe it would have been 20, or maybe it would have been 21. And so they hadn't filled in the blank until they knew what the price was for sure. I mean, those were the types of arguments he was making, and this wasn't one of them. And it wasn't one of his arguments. It wasn't it wasn't anything I can recall us responding to because it wasn't in his briefs, and it had no impact, no discernible impact on Vice Chancellor. Maybe by that time he had become Chancellor Brown. He's somewhere in here. He got elevated from being Vice Chancellor to the Chancellor, maybe a little bit later.
I do want to touch on what you mentioned before about the negotiations, and because on February 28th, the Signal Company's team has an executive committee meeting where they're planning to approve the offer to UOP, and they invite Crawford, the CEO of the seller, to attend the meeting where the buy-side executive committee is going to decide to make the offer. And around that time, maybe immediately before that meeting, Crawford finds out that the proposed range of values is $20 to $21 a share, and says his immediate reaction to Signal is that would be a generous price. In hindsight, was it a mistake to have the CEO of the seller participate in the buy-side deliberations about the
Well,
proposed offer?
I didn't. It was, in hindsight, and certainly under standards that have been applied pretty much since Weinberger, you would not have expected the CEO standing alone without financial help on his side, without consulting with his board to say anything about the offer. It's just, I'll take it back to my board and we'll get back to you. He was called out there. They had already made their 20-21 decision. So the fact that he was invited to sit in at the executive committee meeting where they formed, that had nothing to, that was of no, to me at least, that was of no moment. What was of moment, or certainly was of moment in hindsight, was the fact that he should have done more. He shouldn't have taken it upon himself on a matter like this to in effect lock in or theoretically lock in his own board before they had a chance to even hear what was being proposed.
And it seems as if the discussions with the SEC made this a real headache because the proxy statement, the deal ends up being at $21.
Yeah,
which
so
is
he
the
does
high
go
end.
back. He does go back to his board, consults with them, and gets back to Signal and says, "It's clear from my board that it better be 21, not 20." Okay, so there was some, in that sense, there's some negotiation. It really is. Now, it's not the full-throated negotiation that we would expect today, but there was negotiation. And the record shows that it wasn't that the SEC said you have to put in discussion instead of negotiation. It's that the SEC raised, as they do in their comment letter, raised a question. They wanted details about the negotiation. And to avoid having to deal with that, the corporate lawyers apparently just said, all right, well, heck with that. We'll just change it to discussions and leave it at that. And that's how it happened.
So the plaintiff's lawyer saw the change in from the preliminary proxy where it described negotiations to discussions in the definitive proxy statement and said that's a concession that there weren't any negotiations. That's another argument for an unfair deal.
Yeah, and a little bit more than that. I mean, he would have wanted a fuller exposition of what these discussions weren't. Okay.
You mentioned Lehman Brothers and the speed at which they prepared their fairness opinion, and the post-trial opinion describes how the Lehman Brothers team was working over a weekend because the offer is made on February 28th, and then by March 6th, Lehman Brothers is rendering its fairness opinion. So it's 4 business days. They prepare their financial analysis in those days and over the weekend while Glanville, the lead member of the team at Lehman Brothers, who's also a director of UOP, is on a holiday weekend in Vermont. Then he gets on the plane on March 6th and he has this fairness opinion with the blank in it. You said earlier that you thought that the fact that there was a blank in there was actually a good fact.
Well, I didn't think I didn't read it the same way. There was no decision yet on the UOP side as to whether they were going to take 21, whether they weren't going to take anything, whatever was going to happen. I don't think it was unusual in this context to have a blank in an opinion until you knew what the price was that you were definitively being asked to opine on. That's all I'm saying. And Glanville, of course, today, if somebody was a director and you were getting a fairness opinion from an investment bank and he was a director of the company, I don't think you'd hire that investment banker. Back then, our sensitivities on that were not as well developed. On the other hand, Glanville had been a director of this company, and he had been, unless he was completely brain dead, and there's no indication he was completely familiar with the company's financial situation. And Lehman Brothers, had been tracking the company, I'm sure, because Glanville was a director. So the idea that you could get together and do evaluation in 4 days, 4 business days for an investment bank is, I guess, is most most investment bankers, when they do their opinions, they're probably done in 4 days. So sometimes they're not asked to give them in 4 days. But when you have a familiarity with the company already and stuff in your files about it, that wasn't crazy. It's sort of in the sort of overall picture, not a positive. It's a bit of a negative. But certainly one that Brown was, Vice Chancellor Brown was prepared to move beyond. That argument didn't sway him.
Right, let's talk about that. The post-trial opinion results in a complete defense verdict,
Right.
Or defense result.
Right.
Judgment in favor of Lehman Brothers, judgment in favor of the signal companies and the defendants, no material misrepresentations to the stockholders,
Right.
no breach of fiduciary duty by the target board.
Right.
There was a reasonable basis for finding that the merger price was fair.
Right.
What was your reaction at the time?
Well, I was glad we won instead of we lost.
How did you celebrate?
We didn't sell. I don't remember in these cases. I don't know about other people, but I had lots of cases at this point in time. I didn't have time to celebrate. I just was happy to put this one off to the side until I knew what happened next and move on to the next one. I mean, we were already. They were just. I was doing 2 and 3 takeovers at a time. This was just one case.
You just
certainly didn't celebrate.
You just left the empty champagne bottles in your office.
There
and
were
kept
no
going.
champagne bottles in my office.
Did you expect that the case was over, or did you think that there would be an appeal?
Oh, I thought there'd be an appeal. He had already appealed, had an interlocutory appeal on one matter. By the time I got to Van Gorkum, I knew when there would be appeals, because I knew Bill would never quit. He would play it out to the end. And I think I sort of knew that by this time.
So let's talk about the first Delaware Supreme Court opinion. It's February 9th, 1982, and I want to focus on the decision makers, Justice Duffy, Justice McNeely, and Justice Quillen. What was oral argument like before this court?
You know, I don't remember much about oral argument before the court. I don't think it was. I mean, we ended up with a dissent by Justice Duffy, which was unusual. So my guess is there was. There were some questions. I don't have any recollection of that, and I don't think we have the transcript of that.
Was there a dominant personality among those justices?
Not like there was on the next opinion. Let me put it that way. I mean, Justice Quillen was a good judge and had been a chancellor, and Duffy had been a chancellor, and I think that all had something to do with it. I mean, we're talking about a standard of review that is pretty favorable in terms of a fact determination by a sitting judge on the Court of Chancery, and I think those two, and to maybe a lesser extent McNeely, but McNeely wasn't a very dynamic judge. They trusted Grover Brown. He had been a consistent judge in terms of his performance, and I think they were prepared to defer to him unless there was something really out of sorts. Now, Duffy obviously found some things out of sorts. He had an objection to the Lehman performance, and I don't remember he had another objection also, and he expressed that in his dissent.
So there's a majority opinion. It's 5 pages long.
Right. Which is really sort of we defer as a practical matter to the factual findings and conclusions of the judge of the court below.
And you mentioned the dissent, 6 pages,
Right.
raises the Lehman Brothers issue, and also raises an issue about who, as a practical matter, was given the burden of proof. And
Yeah.
there's a suggestion that Justice Duffy believed that the Vice Chancellor might have required too much from the plaintiff.
Plaintiffs, yeah.
No mention of the Arledge and
No.
Chaitia report
No.
in either the majority opinion or the dissent.
No.
So at this point, you've gotten a full defense judgment at the trial court level. The Delaware Supreme Court has just affirmed. Did you think the case was dead?
Well, I figured there'd be a re-argument of it, because of the dissent. Now, at some point in time, the court, as a matter of policy, came up with a policy that if there were a dissent, then there would be a rehearing en banc. I can't remember whether that policy was in place in 1983 when this opinion came down, but you at least figured there'd probably be a motion for re-argument because of the dissent.
I do want to address an asterisk that appears in the opinion, and it says, the justices named are the only members of the court qualified to sit in this appeal.
Okay, so then I'll just talk about this because it's an important part of what happened. Whether it would have changed the result or not, who knows? But one of the justices that wasn't on the panel was the Chief Justice, Daniel Herman. And he wasn't on the panel because his son is a partner at Richards, Layton and Finger. And Frank Bellotti of Richards, Layton and Finger was representing Lehman Brothers. So he couldn't sit. The other person who wasn't on the panel was Justice Horsey. And there's a comment in some of the later papers about some time limit that had to expire, and it hadn't expired before Justice Horsey could sit on this case. And it hadn't expired at the time of the first argument, but it had expired at the time of the second argument. Now, I just don't remember what that particular time limit was or what the policy of the court was that said he couldn't sit until some period of time went by. But I do know, I'm convinced to this day that Bill Prickett was smart enough to say, and what he did was he dismissed Lehman Brothers. Okay? That requalified Chief Justice Herman. He wanted a different panel than had decided this. And then Justice Duffy must have retired, and Drew Moore came in, and then Horsey's time went up, and he came on. So when the matter was reheard en banc, of the three judges that were originally there, only, well, McNeely was still there. I guess Quillen was still there.
Two left.
Two left, and three completely new ones. And it had to be that the dismissal of Lehman Brothers was to requalify Chief Justice Herman.
It seems brilliant because the dissent focuses on Lehman Brothers,
Yeah.
and one would expect that if you were to seek re-argument, you'd want to capitalize on Lehman Brothers, and yet
he just threw really well. It was so much more important to get a new panel than it was to try to exploit the dissent. Is the way I read it at the time.
So-
and do to this day.
the plaintiffs decided to throw away their claims against Lehman Brothers to reconstitute the court. It seems brilliant or dastardly,
Or something.
depending on your perspective.
That's correct. That's a fair way to put it.
So let's talk about the court on rehearing. Two of the justices are the same. There are three new personalities.
Right.
Is this court a totally different animal?
Pretty different.
How so?
Well, largely because of the personality of Justice Moore, and it was Justice Moore who jumped all over the Aldrich Chaitya report from the very beginning of the oral argument. He didn't even wait for Halkett to get up. He started making his points with Bill Prickett. And at this point in time in history in our court, the court, even at this early point, it became even clearer as time went on, and we went to cases like Van Gorkum and some of the takeover cases, the Unicals, the Revlons. The court had sort of ceded the lead position in these corporate transaction type cases that it reviewed to Justice Moore. He was by far the most influential justice on the court, and particularly the relationship between he and the Chief Justice meant that every time Justice Moore said something, the Chief Justice sort of echoed it, and you can sort of see that in the transcript if you go back and look at it. So people came in to argue about one thing, and oh, by the way, the court decided in re-arguing, and what it did was it vacated the earlier decision. I mean, got rid of it. Had to get rid of it because it said it was en banc, and there's no procedure for having a re-argument of an en banc. So they basically said this was never really an en banc thing in the first place. So we get rid of that. We have re-argument, and we're going to decide it based on the briefs that were submitted through two or 3 years ago on the first argument. There were no new briefs. So, which is a sort of strange thing. I don't think that I can't remember seeing that much. In fact, sometimes the court is very helpful in these circumstances and actually tells the parties what's bothering it and says, please address question A, question B, question C. In some of the very biggest cases, they did that. They did that in Unical, for example. But here they didn't, and it all happened at oral argument. And after sitting there and listening to umpteen questions about how could you possibly not think that this Arlish Chatia report, prepared by two UOP directors who are also signal directors who using signal information, how could you possibly believe that that wasn't a breach of fiduciary duty? And you hear that about 5 times. You say, when is it that you realize you're in trouble in a case? Well, on that one, I had to have realized that we were in trouble. It was pretty clear where they were headed. Now, all of the things that they decided in the opinion, and there are a ton of them, where they really remade the law in terms of controlled mergers. All of those things weren't raised in oral argument. Many of them weren't even discussed by either side in the briefs. But on this point, which was the real point, and if you look at it closely, I think the result would have been different if there hadn't been an Arlish Chatia report. On this point, it was pretty clear where they were headed. So I'm sure that the drive back from Dover to Wilmington was not a gleeful one.
Did you have to report to anybody about the oral argument and start to manage expectations? Or?
Not really by this point, because by this point, UOP had been, I didn't, okay, I personally didn't, because UOP had been a wholly owned subsidiary now of Signal for the better part of 5 years. Now, Alan Halkett, who made the argument, I'm sure had to report to Brewster Arms, who was the general counsel of Signal, as to what happened. But I don't remember being on that call. I wouldn't have normally thought I would have been on that call, although it's possible I may have sat in on a call and thrown in my 2 cents worth. But it was pretty clear where we were headed. And there was a letter that we sent after, which is very unusual. There was a letter we sent after the argument based on some testimony by Walkup, who was the chairman of the board of Signal, but had been at the UOP meeting, where he had a recollection that he had shared the Arlish Chatia report with the UOP board. But there was no corroboration of that. There was some sense that maybe a couple of pages had been shared. And in the end, the Supreme Court actually said, we did fact-finding. We went back into the record, and we looked at the record, and we believe on the balance of facts, which is sort of a trial court function, that didn't happen, and therefore then build its decision around that finding of fact.
And that finding of fact relates to an issue that wasn't even the focus, either at the appellate argument before or at the trial level.
Or in the briefs before the Supreme Court, which had been written 2 years before for the first trial. For the first appeal.
So the opinion comes out on February 1st, 1983. Right. It is, I think, what an observer at the time must have thought was a stunning reversal. Can you remember the atmosphere in the legal community, or at least in the defense bar, to the opinion?
Well, I don't know if this case had gotten to a point in terms of people looking at it like they were looking at some of the big takeover cases, that it was viewed as some sort of stunning reversal. I think people looked at it almost like the Supreme Court writing a law review article or a statute for all the things that were in the opinion. Doing away with the Singer-Tanger-Najar business purpose test, saying that this could have been completely different if there had been a special litigation committee formed of the independent directors to negotiate, abandoning the decades-long block method of deciding appraisal cases and saying we're going to apply an expanded, more liberal method, including things like discounted cash flow, both to this type of case and to appraisal cases. They actually all go on and say we're sort of relegating, this was sort of hopeful thinking that never really happened, but we're sort of relegating people back to the traditional remedy of appraisal. I think they would hope to sort of end these cases and just have appraisal cases. That really didn't happen. But there were just all of these findings, many of which had never been discussed by the parties. I mean, on the business purpose thing, our position had been twofold. Number one, that the majority of the minority vote really did away with the business purpose concept because that had not been present in any of these business purpose cases. But number two, the latest case in the business purpose area had been a case called Tanzer, and it had said that a business purpose of the parent was sufficient. And we had a ton of business purposes of our parent. We had a lot of excess cash, and we didn't know how to invest it. And so we had said, but even if we're wrong about the majority and minority vote thing, we've satisfied the most recent of these cases. So in a way, when you look back on it, the business purpose was sort of on its way out in Tanzer. By the time the court said it can be the business purpose of the parent, it didn't have much meaning. It would have only been in the case where parent had a personality conflict with the minority stockholders and had no business reason for doing it, that I suppose it would have still had life. So getting rid of it was a bad idea to start with, and getting rid of it was, but nobody argued that. I just told you what we argued. Prickett argued it was still vibrant, and so the court just said, we're reforming this whole picture, and we're going to get rid of that.
I do want to mention something that you said a moment ago about the Delaware block method. The opinion describes the Delaware block method as clearly outmoded, and then goes on to say that a more liberal approach must include proof of value by any techniques or methods which are generally considered acceptable in the financial community, and otherwise admissible in court, subject only to our interpretation of 8 Del C Section 262. Why did the Supreme Court do that?
Well, I think by the time we got to the mid '80s, it was pretty clear that the block method wasn't. No investment bankers were doing the block method in terms of actually making decisions on how to advise their clients in these types of transactions. It just wasn't. It wasn't modern, and frankly, Justice Moore knew that, and so he came in and said, "Well, this block method is and we're being laughed at. We're being laughed at in the business community because of the application of this block method. It meant that the values you were putting on companies for purposes of buying them didn't mesh with the appraisal values that somebody who dissented might get, and that could end up with a higher value or a lower value, but it wasn't. But it was pretty clearly not calculated anymore to give people what they had, a substitute for what they had before in any rational way. And of course, the worst thing about it is it was backward looking. So you look at. I mean, we all have been conditioned now for 40 years to look forward, and we look at projections, and we base our valuations in making decisions as to whether to buy stock or not buy stock, based on the projections that you see, and capitalizing those with some discount rate, and looking forward. I mean, 5 years is a long time. It's gotten to be shorter and shorter and shorter in terms of modern businesses. I mean, it might have been great to have Blockbuster's 5 years historical earnings, and you would have paid $1 zillion. But by the time you got to that point, it was already pretty clear that Blockbuster was on the way out and Netflix was on the way in. So it just didn't. That's just an example. I mean, there wasn't any litigation about that, but that's the difference, and that's become even more important as business cycles and innovation get accelerate and have accelerated.
There's a discussion about modernizing the appraisal statute, but the case isn't an appraisal case.
That's right, but they were saying we're going to view it as an appraisal case, a quasi-appraisal case, and they had some gibberish in there about preserving this quasi-appraisal remedy for cases that were in the court, or about to be in the court, or in the court below, and I don't know if that ever had any effect on anybody or anything. And then everybody else is going to get relegated to appraisal. Well, that didn't happen. And so, in effect, the valuation methodologies that it formulated continued to be used in various valuation efforts in takeover cases from this point forward. There's another thing, by the way, this case did, which I can't remember all of them. There were so many innovations and changes. There had been a case called Lynch 2. And Lynch 2 had said that the only remedy for a cash-out merger, and I'll get back to that in a minute, but the only remedy was rescissory damages, which was also a bizarre concept. And the Supreme Court also said, by the way, we overrule that. That's out of the picture. That it's anything that it's any form of money damage that seems appropriate in the case. And then we had the damage trial, which we'll get to in a minute, I assume, ended up being a textbook demonstration of how rescissory damages can't work in a circumstance where the case is being tried 7 years after a merger in which the company basically had disappeared 4 years earlier, and all sorts of decisions had been made that scrambled the eggs. So,
you mentioned the damages trial. There's an opinion before that, April 24th, 1984, where the court rejects the argument that the rescissory damages are out of the picture.
Well, what happened there is if you're going to try a rescissory damage case, you have to open up discovery, and discovery in this case had been based on what happened in 1978. Okay? If you're going to try rescission, because rescissory damages in theory is the highest value that you might have received in the period between the time of the merger and the time of the decision on the damages. That's a 7-year period, or a 6-year period. I can't remember, it was 84, 85 that we did the damage trial. So we had tried to convince the court, look, the eggs are so scrambled, you can tell now you don't need a trial to tell that they're so scrambled that rescissory damages won't work. Let's just try the damage case, a regular damage case. And the reason we did that was because we didn't want to bear the expense of document production for 7 more years, and more depositions on that. But we lost, so we did have to bear that expense.
So let's roll forward to the damages trial. The court decides that it can't award rescissory damages, and it goes on to say that the minority, and I'm quoting here, should be compensated for the wrong done to them, even though a damage figure cannot be ascertained from a comparison of selected stock values and hypotheticals with any degree of precision. It suggests that the court is very uncomfortable with any damages analysis.
Chancellor Brown hated this case. I mean, it was clear from the beginning he didn't like this case. There was a 50% premium being paid to the market. Almost everybody almost nobody, 147,000 shares out of 5 million didn't like it, or at least demonstrated they didn't like it by not turning in their shares or voting against it. And I just think he thought, and the nature of Bill Prickett's complaint was like, first it's filed a couple of months after the merger, rather than anybody trying to enjoin the merger when it could have been straightened out in a timely way. And then it clearly takes on the look of a complaint searching for a cause of action. You know, you file one, that doesn't work, so you then come up with another one. Yes, you had the benefit of discovery, but the stuff that he came up with wasn't very persuasive. Nobody raises in the court below Arlen Chartier, and all of a sudden the case comes back to him. And I just think he said, I've had enough of this case. And the rescissory damage proof I put on, I actually went back and read the transcript because I didn't remember I'd even put on a witness. But we had like 3 witnesses. We had a guy from UOP who was the chief financial officer of UOP, and I put him on and just took him through all of the things that had changed at UOP, and frankly blew out of the water a lot of the supposition that their banker had made about timberlands. You know, we got this great valuable timberlands. Well, yeah, but except we had these, except they had been in a conservation type thing with the state of Michigan and the state of Wisconsin for 40 years. And if we ever did anything other than just harvest timber, for which we got almost no money, we would have to pay back all the taxes that we had saved because we had put them in the conservation thing, and it would have been a negative number. I mean, he got rid of that. The company had stopped keeping its own money, and UOP had started, or Signal had taken over the treasury function and was paying its bills. This come by chance thing had resulted in something like an $80 million judgment against the company. I mean, the whole idea that there was going to be any way that you could pick a time and say, I've got a time where rescissory damages were here, and it would have been appropriate, and somebody would have done better than 21. There was no way he could have decided that. Just no way. There's no way with any intellectual integrity. So then he's left with Purcell's testimony, where I guess in this trial we must have had Purcell do a discounted cash flow. I think we did. And he's got Bodenstein. And he didn't like Bodenstein's testimony any more than he liked it the first time. And so what's he left with? And he doesn't call it nominal damages, but that's probably sort of what it was. He says, well, Purcell said he could have given a fairness opinions at 20 or up to 22. I mean, well, yeah, that's not really very exciting. He could have given a fairness opinion at 100 to the minority stockholders of UOP. And he has a few other words about, and I know I have to give him something because the Supreme Court has said that they've been deprived of the right to intelligently make a decision. But on the other hand, he says, but don't forget that we are only in this box because Signal created it by trying to be generous to the minority by making it a majority of the minority vote in the first place. So I'm giving them $1 a share. So think about that. So the class has been expanded, obviously, because it's now a disclosure case from 147,000 back to 5 million. So we've got a $5 million judgment. And by the way, by this time, Signal had merged with Wheelabrator, and then I believe it also merged with Allied, and it had become Allied Signal. None of the people at Signal were even there anymore. And Signal was like, 5 times larger than it ever had been before. $5 million to Signal was nothing. I mean, it was chump change by this point. And so poor Bill, having put in thousands of hours over the course of 7 years, ends up with a $5 million judgment, of which I don't remember what the fee is, but assume he got the largest fee that our court would theoretically give, which would be for all the effort he put in, which he would have clearly deserved a fee of a third. I don't know if that's what he got, but we're talking about, less than $2 million for just thousands and thousands of hours. And in his and to add insult to injury, so we get the opinion from Grover Brown, who was by then chancellor, about $1 a share. And I think I pretty well recall that I had a part in this. I think I was the instigator and said, why don't we do a motion to affirm? Because I said, I don't think the Supreme Court, first I had all this language about discretion. We're giving it to the discretion of the court below. And I said, I don't think the Supreme Court has any stomach to hear anything more about this case. So why don't we try a motion to affirm? So in Delaware practice, if the plaintiff appeals, which Bill Prickett did, he appealed the $1. He said this was like nothing. This was a horrible result. And we originally cross-appealed, and then we decided not to cross-appeal. So we withdrew our cross-appeal. Instead, we filed a motion to affirm. And a motion to affirm basically says the defense is saying that you're not allowed to say any argument. You just say, we move to affirm, and the standard on the motion to affirm is just looking at the appellant's brief that there's no way they can win. That's basically how a motion to affirm works in the Delaware court. And the court summarily granted a motion to affirm. Bill moved to re-argue. They summarily got rid of the motion to re-argue, and that was the end of the case. So it finally ended, and it ended in a very truncated, unusual way. It was sort of like nobody wanted to have anything to do with this case anymore. But what it left behind was an entirely new regime in terms of parent-subsidiary mergers and cash-out mergers, which survives to this day. I mean, it is nobody after this opinion would really do a cash-out merger without having a special committee of outside directors negotiate. I don't think anybody would ever. I think by this time you would think 3 times before you had picked an investment banker that where you had a director from that investment banker on the board. All of these things were basically dictated by this case, which really revolutionized and brought into the modern era how we deal with this type of conflict transaction.
Thank you very much, Gil. It's been a pleasure, and thank you for sharing your thoughts with us.
My pleasure.
While the cameras are still rolling, does anybody have any questions you want to ask Mr. Sparks? I don't. Pretty thorough. It was a marvelous job. Thank you, Tom.
Now, Gil, is this the only opinion where you thought the learned reasoning and prose in the Delaware Supreme Court was gibberish?
Which one? When did I say that?
Leading question.
That was my favorite part of the interview. Where you,
No, there were some others.
Why did the case never settle?
I don't know the answer to that. I would not have been in the loop in terms of settlement. I mean, any settlement would have had to be in Signal's decision. So it's possible that the general counsel of Signal, Brewster Arms, and Alan Halkett had discussions with the senior executives of Signal about possibly settling it at some point. But I'm pretty sure I wasn't a party to those, if they happened at all. I just don't know. And if you look at how this developed, I mean, the Artis Chaitya thing came sort of out of left field at the argument. I suspect Bill didn't have a lot of leverage before that argument. Whatever leverage he had after that argument, he thought he probably had more than Signal would have thought that he had. He just played it out to the end, just like he did in Smith versus Van Gorkum. I mean, Bill Prickett certainly he was a bulldog in terms of taking these matters and taking them to the end, and he was very successful in doing that. Now this one, I don't know whether Bill considered. I'm sure Bill considered it a victory, but I'm not so sure he considered it an economic victory. But Smith versus Van Gorkum was another example where we won and we won and we won, and finally on re-argument in Bonk, we lost. And that was just because of Bill's perseverance.
Gil, could you, that's interesting, the juxtaposition actually of Van Gorkum and Weinberger. How do you balance the overall utility of those decisions? Because I sense from both of you that there's a sort of profound concern about due process to the folks who were operating in real time and then being assessed by evolving standards 6 years after the fact in both cases. But as you said, there were profound evolutions in Delaware law, and you know, is the law better off for these two things, or?
Oh yeah, I think it is. I mean, if you think about, I like to think about basically Van Gorkum, which basically emphasized the duty of care and did some other things. Unical, which put a huge premium on having boards dominated by outside directors. In this case, which basically said, if you think you're going to come before our court again, things will probably be completely different if you have an outside negotiating committee made up of outside directors. So both of those cases put a premium. Those cases put a premium on outside directors. Modernized how you look at the economics. Emphasized the fact that there better be a process, as Van Gorkum did, and put together those three cases. I think have established the model which we, with a little tweaking here and there, rely on today to maximize the chance that these conflict transactions are as close to being arm's length as they can be. And I think those are the three opinions that probably were the most influential in shaping that total picture.
As an historical matter, and I think it's interesting to think about Weinberger, because I think we often think about the other cases. You know, I think we've grown in thinking that Van Gorkum has to be looked along with Unical and Revlon. Is what you're saying there were some real societal pressures on Delaware,
Right.
and whether this tradition of the business judgment rule approach could be maintained, and that Weinberger was one of the critical decisions in saying it. If we're going to maintain it, we have to do it with credibility so that we can face the mirror test. And I take it what you're saying is across the board, the court was trying to take the traditional Delaware way, apply it to an evolving markets, but in a way where it had genuine integrity.
Right, and these cases, you know, it's funny. Some of them started earlier, but they all got decided within a period of maybe 2 to 3 years. So this was, what's the date on the Supreme Court's opinion here?
83 for the reversal.
And then Van Gorkum is 85, and Unical is 86, and all of these things are happening pretty much. There's some other cases coming out, sort of filling in little blanks all during that period, and it was Delaware's response to a system that when you entered the 80s and you entered this takeover era, which we had never had before. I mean, the first real takeover that I remember was one that at least I did, but it was one of the very early ones, was 1978, which was Carrier and United Technologies. And as you entered into this period, there was no law. I mean, our law just hadn't caught up with it. And the big question was, would you test these under this entire fairness concept, which we use for conflict transactions? The Singer Magnavox case, which I mentioned here as being one of the ones that you look to. Or would you measure it by the business judgment rule, which was very deferential? And the takeovers were a little bit different because the directors didn't face a pure conflict of a monetary nature, but they faced a challenge to their directorships, because if they got taken over, their directorships were going to be gone. It was more of a, the concern was more of a losing face. About at that time, we weren't paying our directors of major corporations $400,000 a year or $300,000 a year, which we seem to pay them now. They were probably getting paid 20. And so it wasn't, and they were all people of means, so it wasn't like they would miss the money, but they didn't want to. But there's sort of a fighting instinct. You don't want to lose, and so the Supreme Court in the end, and it ended up in Unical, fashioned a standard that was in between, with sort of a preliminary determination that what you did was reasonable in relation to the threat posed, made sure that everybody understood that directors' duties under our statutes included not just running the internal affairs of the corporation, but also protecting the stockholders, and all of that, plus these cases, focusing on process and procedure, allowed us to sort of move forward and really vitiate the criticisms that had begun to grow as people didn't understand how this was going to work. And almost none of that was by legislation. It's a great example of the common law reacting to establish things that, frankly, are almost read-like statutes when you look at Weinberger and the things that they repealed, if you will, and the things that they adopted. So it's an important case, and maybe with this background, when you all look at it, you can take a look at it and count up the things, including the footnote 7 that talks about special committees and all the other things that they sort of said, well, we're overruling Lynch 2. We're overruling purpose. We're adopting this new appraisal evaluation concept. All of these things that they did, it's fairly remarkable.